Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. Today's episode will be somewhat different from our typical format. Instead of reviewing a police interaction, we will be taking a look at past episodes that didn't necessarily have a resolution at the time of our coverage and see where they are now. This is technically part 2 of this update series, and you can find part 1 on my second channel. Rather than having to wait months for a new upload on the second channel, we are going to turn this into a formal series right here on ATA and give you periodic updates as they come along. It can take years for these cases to reach any meaningful resolution, so there's no scheduled timeline for when these update episodes come out, but we will try to release one as often as we can. Be sure to let us know if you enjoy this format in the comments, and also let us know if there are any particular episodes that you would like to see included here. If you enjoy the content that we produce here at ATA, be sure to like and subscribe. It really does help us grow and reach new people. Without further ado, let's dive right in. The first episode that we're going to be taking a look at happened back in August of 2022 in the town of Molina, Georgia. 2 unidentified officers from the Molina Police Department pulled over Chief Jonathan Hemphill of the nearby Zebulon Police Department because he flashed his lights at them as he was passing them in his unmarked cruiser. The Molina officers had no idea who he was when he flashed his lights because his car was unmarked and had very dark tinted windows, so they reasonably assumed that he might be someone attempting to impersonate a police officer. Needless to say, Chief Hemphill wasn't very happy about being stopped. The chief was eventually allowed to leave the scene without being arrested or issued any citations. 5 days after the encounter, the Zebulon Police Department abruptly ended an agreement that had been established with the Molina Police Department that allowed them to use each other's radio frequencies in emergency situations, which forced the Molina PD to use a different neighboring department's radio frequency. About 2 months later, in October of 2022, the city of Zebulon announced that they had hired an independent third party to investigate the chief's conduct and make recommendations about how to move forward. When we left off our coverage, that investigation was still ongoing. The Molina officers got an A in this episode, and Chief Hemphill got a C-. On December 13th, 2022, Zebulon council members announced that the investigation was complete. They approved a motion to give Zebulon Police Department Chief Jonathan Hemphill an oral reprimand and required him to attend post-training related to anger and de-escalation. So basically, they told him not to do that again and sent him to therapy. It was reported that the radio change was a mistake, not an act of retaliation, and that the Molina Police Department does have access to the Zebulon emergency frequencies now. However, Molina Police Chief Matt Polk was quoted saying this about why they had lost access to the frequency. Quote, "I was advised on September 30th, 2022 that I needed to find another radio channel by Chief Hemphill after he was told no disciplinary action would be taken against my officers regarding the traffic stop because, after reviewing the video, it was determined they did nothing wrong." So there's almost no doubt that Chief Hemphill blocked access to the radio frequency in retaliation for the officers not being punished. This is kind of like going through a breakup and having the Netflix password changed on you, except that other citizens who pay for all these emergency services are the only ones actually affected by this kind of behavior. So, needless to say, I think Chief Hemphill's conduct was childish and unbecoming of a community leader, and this speaks volumes about his character. If I were a citizen living in Zebulon, it would take a lot for Chief Hemphill to redeem himself from something like that. The next one comes to us from the great state of Colorado and features officers from the Fort Lupton Police Department as well as the neighboring Platteville Police Department. This encounter made national and international news, so I'm sure you all remember when the Fort Lupton officers left then 20-year-old Yareni Rios handcuffed in the back of a patrol car while it sat idling on railroad tracks. Of course, it wasn't long before a train came along and smashed into the patrol car that Ms. Rios was sitting in. Ms. Rios suffered a ton of injuries, of course, but she did survive. It was Fort Lupton officer Jordan Steinke who parked on the tracks and placed Ms. Rios in the patrol car, but it was Sergeant Pablo Vasquez of the Platteville PD that initiated the stop. Another Fort Lupton officer, Ryan Tomachek, arrived on the scene and also participated in the arrest. This all happened back in September of 2022, and when we covered this interaction, Ms. Rios had already stated that she intended to file a lawsuit, and multiple law enforcement agencies had launched investigations into the incident. One of the officers from a nearby department was placed on paid administrative leave, but the Fort Lupton PD had declined to comment. Well, in June of of this year, the Associated Press reported that Ms. Rios had accepted an $8.5 million settlement regarding the lawsuit she'd filed against 2 of the 3 officers involved. The city of Fort Lupton and the city of Platteville both agreed to pay half of the settlement. Now, while this did settle the lawsuit for the actions of Officer Steinke and Officer Tomacek of the Fort Lupton PD, Ms. Rios still has an ongoing lawsuit against Sergeant Pablo Vasquez of the Platteville PD. Along with being sued, all 3 officers were fired from their respective departments, and Officer Steinke and Sergeant Vasquez were charged with reckless endangerment and sentenced to probation. Officer Steinke was also charged with assault, and her probation sentence was about 1.5 years longer than Sergeant Vasquez. Officer Tomacek was not charged with any crimes. So I guess I was wrong about this being the largest lawsuit ever filed against cops, but it still has the potential to be, considering that there may be another lawsuit brewing. It's up against some stiff competition now, though, because it was just last year that civil rights attorney Ben Crump managed to secure a $45 million settlement in the case of Randy Cox in Connecticut. This is now widely considered to be the largest lawsuit involving police misconduct ever won, which was previously held by the $27 million settlement resulting from the encounter involving George Floyd. It's great to see that Ms. Rios is being well compensated for her troubles, and that the officers are being held accountable for their actions. Like I said in part 1 of this series, sometimes these cases can resolve relatively quickly if they prompt social uproar or the acts committed are particularly egregious. It'll be interesting to see where the next lawsuit goes, and I'll be sure to keep you all updated as much as I can. Up next, we have the case of the Alabama pastor Michael Jennings. Back in May of 2022, his neighbors asked him to water their plants while they were on vacation, and being the caring community leader that he is, Pastor Jennings happily agreed. Well, it didn't take long before someone in the neighborhood called to report a suspicious man menacingly watering the lilacs or whatever, and of course, the Childersburg Police Department showed up in full force. Despite figuring out that Pastor Jennings was actually supposed to be at the house and managing to positively ID him, the officers decided to arrest him anyway for obstruction. But a few days later, then Childersburg Police Chief Richard McClelland issued a statement asking that the charges be dropped, which they were. When we left off our coverage of this interaction, Pastor Jennings was in the beginning stages of filing a lawsuit against the city and the officers. Well, in September of 2022, about 3 months after the encounter, Pastor Jennings filed a lawsuit against the city of Childersburg and the 3 officers involved in the arrest. When we covered this interaction, the main focus of our analysis was whether or not the officers had reasonable suspicion in order to require Pastor Jennings to identify himself. The conclusion we reached at the time was that although there was an argument to be made that the 911 call provided the officers reasonable suspicion, the officers' own observations could have served as means to dispel the suspicion. When the officers arrived on the scene, Pastor Jennings told them his name and that he was tending to the house while his neighbors were on vacation, all while clearly watering the plants in the yard. Well, any normal person would have likely come to the conclusion that Pastor Jennings was allowed to be where he was. But the judge in his lawsuit didn't see it that way. Just over a year after the interaction, in December of 2023, a district court judge in the Northern District of Alabama dismissed Pastor Jennings' case and found that although Pastor Jennings' conduct itself did not constitute obstruction, his refusal to identify himself granted officers the authority to arrest him for obstruction. Pastor Jennings' attorney attempted to argue that the officers had not witnessed any criminal activity themselves, so they never had reasonable suspicion, much less probable cause to make an arrest. The judge found that the officers did have probable cause to stop Pastor Jennings under suspicion of trespassing because he matched the description provided by the caller, and the caller did not remain anonymous, which added to the credibility of their call. He went on to say, now quoting, "The fact that plaintiff was watering flowers outside the house does not foreclose a finding of reasonable suspicion. A savvy criminal could easily pick up a watering hose to use as a ruse when officers approach." Needless to say, I disagree with the judge's ruling, and I think it was plainly obvious that Pastor Jennings was not doing anything illegal, and the arrest was wholly unnecessary. Pastor Jennings and his legal team have appealed the ruling, and the case is still pending at this time. It's hard to say which way this case will go, considering that the 911 call likely did suffice as reasonable suspicion. But now it's really a matter of proving whether or not the suspicion was dispelled at any point before the arrest. This can be an especially difficult thing to prove considering the subjective nature of an argument like that, but I am interested in seeing where this case goes, and of course I will try to keep you updated as the case progresses. Alright, so hopefully you all remember this one because we covered it pretty recently. And again, the links to these episodes will all be in the description down below, so if you haven't seen this one yet, then go check it out first. So, on February 9th, 2018, Sergeant J. Riggin of the Vermont State Police initiated a traffic stop on driver Gregory Bombard in St. Albans, Vermont, because he thought that Mr. Bombard had flipped him off as they drove past each other. Now, at first, the sergeant tried to say that he thought Mr. Bombard was trying to signal for help by flipping off the officer, and Mr. Bombard had no clue what he was talking about. Mr. Bombard claimed that he must have misinterpreted his hand gestures and reassured the sergeant that he didn't intend to give him the middle finger. Mr. Bombard goes on to make the point that even if he had flipped off the sergeant, that would be an act of free speech. Well, the two argue for a bit before Sergeant Riggin gives up and tells Mr. Bombard that he's free to go and walks back to his cruiser. As Mr. Bombard drove away, he cursed at the sergeant and intentionally flipped him off. This prompted Sergeant Riggin to initiate another stop on Mr. Bombard, which resulted in his arrest. Mr. Bombard's car was towed, and he was held in custody for over an hour before he was issued a citation for disorderly conduct. While this charge was pending, Franklin County State Attorney Jim Hughes added another count of disorderly conduct, claiming that Mr. Bombard had obstructed traffic as he was moving back into the travel lane after the initial stop. When we left off our coverage of this encounter, Mr. Bombard had both charges dropped, but he was forced to, quote-unquote, donate $250 to a charitable organization because the judge thought that he needed to, and I'm quoting, learn a lesson. That's an actual quote from the judge in his case. On February 4th, 2021, Mr. Bombard filed a lawsuit against Sergeant Riggin and the state of Vermont with the help of the ACLU, and at the time of our coverage, the lawsuit was still pending. Well, on June 26, 2024, the Foundation for Individual Rights and Expression, also known as FIRE, announced that Mr. Bombard's case had reached a $175,000 settlement, with $100,000 going to Mr. Bombard and $75,000 to attorney fees. In the article, Mr. Bombard said, quote, "With this settlement, I hope the Vermont State Police will train its troopers to avoid silencing criticism or making baseless car stops. And at least now I can pay my criminal attorney for defending me from the bogus charges and take my 88-year-old mother out for a nice dinner." Well, I'm glad that Mr. Bombard was compensated for his troubles, but it's still insane to me that even an open and shut case like this, with the help of the ACLU, still took over 3 years to come to a conclusion. This just goes to show that even if you are clearly a victim of police misconduct and you have the resources of essentially the most powerful civilian rights organization at your side, it can still take years for any meaningful progress to be made. The next one was one of the most ridiculous interactions we have ever covered on this channel, and if you haven't seen it yet, then I highly recommend checking it out because it is both hilarious and insane. Back in February of 2017, attorneys Victor Revel and Megan Garcia were leaving a courthouse near Birmingham, Alabama with their client when they were confronted by Deputy Ashworth and Deputy Ratliff of the Blount County Sheriff's Office, who were attempting to serve a search warrant of their client and his vehicle. The deputies were trying to gain access to the client's phone, which had been placed in Mr. Revel's briefcase just before exiting the courthouse. Mr. Revel quickly read over the search warrant and pointed out that it pertained to the client's person and vehicle, not to Mr. Revel's briefcase, and refused to allow the deputies to search his briefcase without a warrant explicitly granting them that authority. Well, after a heated debate, the deputies eventually arrested Mr. Revel and Ms. Garcia for obstruction based on their refusal to comply with the warrant. Eventually, a judge acquitted Mr. Revel and Ms. Garcia of all charges and stated that the deputies were wrong about the authority of their search warrant and that the defendants never physically prevented the deputies from carrying out their duties. Mr. Revel and Ms. Garcia filed lawsuits against the deputies involved, along with the district attorney and assistant district attorney who gave the orders to make the arrest. When we left off our coverage of this encounter, the lawsuit was still ongoing. Well, Mr. Revel and Ms. Garcia's case has since made its way to the 11th Circuit Court, which is just one step below the highest court in the land, the Supreme Court. However, it has faced some challenges. Unfortunately, the 11th Circuit concluded that the deputies involved in the encounter were entitled to qualified immunity and stated, quote, "We are confident that even if the defendants did not have probable cause, their error did not violate clearly established law, entitling them to qualified immunity. In other words, it's the age-old excuse of quote-unquote clearly established law that saved the deputies from being sued into oblivion. But the district attorney and the assistant district attorney weren't so lucky. Not only did the DA and assistant DA play a role in having Mr. Revel and Ms. Garcia arrested, but they also went out of their way to make defamatory statements about them after the arrest as well. This aspect of the encounter was also a part of the lawsuit that the two filed, and the 11th Circuit essentially ruled that they are liable for their defamatory statements. The case was sent back to its respective court to be resolved, and it's still ongoing. Although the 11th Circuit Court granted the deputies qualified immunity, Mr. Revel and Ms. Garcia will still have the opportunity to appeal this decision to the Supreme Court if they choose to do so, and the victory on the defamation aspect of this case is well earned. This case is far from over, but it looks as though it may have a positive overall trajectory considering the circumstances. Once again, I'll try to keep you guys updated on the status of this case periodically. The last interaction that we will discuss today is one that we covered about 3 years ago, but it actually took place in November of 2019. Two City of Brookings police officers stopped 49-year-old Jennifer Gaiman on her mobility scooter as she traveled home from a night of karaoke with her friends in Brookings, Oregon. Ms. Gaiman, who has been diagnosed with several chronic disabilities, was stopped for riding her scooter on the sidewalk. The officers argued with Ms. Gaiman about whether or not her scooter could be legally ridden on the sidewalk, and demanded to see her identification. Ms. Gaiman surrendered her identification, and the officers wrote her multiple citations and informed her that she would not be allowed to ride the scooter home because she did not have a helmet. Ms. Gaiman decided to ignore the officers' commands and attempted to drive the scooter home anyway, which prompted the officers to engage in a low-speed pursuit with Ms. Gaiman before eventually arresting her inside her garage. Ms. Gaiman was arrested for attempting to elude police and interfering with an officer, and was eventually convicted by a jury for the eluding charge and sentenced to serve 5 days in jail with 18 months of probation. When we left off our coverage of the interaction, Ms. Gaiman had appealed her conviction and had filed a lawsuit requesting $500,000 in compensatory and punitive damages, both of which were still pending. Well, in June of 2021, the Court of Appeals of the State of Oregon acquitted Ms. Gaiman of the eluding charge and noted that, now quoting, "The actions of the state in this case, from the police officer's decision to pursue defendant in a low-speed chase for the $25 specific fine traffic violation of not wearing a helmet, to the prosecutor's decision to pursue a felony charge under those circumstances, to the Attorney General's office's decision to defend those decisions on appeal, should not be ignored, and the case remanded for further prosecution when the answer to the legal issue presented is clear. Defendant should not have been convicted of fleeing or attempting to elude a police officer for using her mobility device to get home after a traffic stop." Well, not only did Ms. Gaiman have all her charges acquitted, but in March of 2022, just over 2 years after the initial incident, she was awarded $300,000 as a settlement agreement with the City of Brookings. As part of the settlement agreement, the City of Brookings issued an official apology to Ms. Gaiman and mandated that all its officers undergo Americans with Disabilities Act training. This case demonstrates the critical balance law enforcement must strike between enforcing the law and exercising discretion, particularly when dealing with individuals with disabilities. The officer's decision to escalate a minor traffic violation involving a mobility scooter into a low-speed chase and arrest for eluding police illustrates a disproportionate response that ultimately led to significant legal consequences. The Oregon Court of Appeals' clear rebuke of the state's handling of the case reflects how unnecessary force and overreach in enforcement can not only erode trust between citizens and police, but also lead to costly legal repercussions for municipalities. That's all the updates that we have for you in this episode, but as mentioned before, there will be more update episodes to come in the future. Remember to let us know if you enjoyed this type of episode in the comments, and suggest some episodes that you would like to see updates on. If you could take a moment to like and subscribe, it would be sincerely appreciated. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.